The first thing I just wanted to mention is just some of these backstories, because you hear about the legal precedent, and we're talking about ineffective assistance of counsel, but it's really, if you really want to get a true reflection of what the system is about and how it fails on these very important matters, you take a case like Hinton, okay, which Bryce mentioned. And Hinton is a case that starts out in Alabama. And it's a case where two people from the local crime laboratory who were their ballistics experts both offered testimony erroneously connecting a gun that belonged to the defendant's mother to the commission of these two murders. And what's interesting about the case is that it was taken up post-conviction by Brian Stevenson, who some of you may know is probably one of the top lawyers in America. Started the Equal Justice Initiative and has won every award that you can possibly imagine. And he went out and he, in 1998, secured the efforts pro bono of the leading ballistics expert at the FBI and two of the other leading ballistics experts in America who had written most of the books on it. And the three of them acting as a peer review committee looked at the work of the two Alabama fellows and said they're completely wrong. And in 1998, he had that report. And he took it to the police, he took it to the state police, he took it to the district attorneys, he took it to the Attorney General of Alabama, and no one would listen to him. No one would reconsider the initial conclusions that were made in the Hinton case when this man was convicted of these two murders. And he kept pounding away from 1998 until 2014. And in 2014, Brian Stevenson, with all of his stature, gets up before the U.S. Supreme Court and basically argues that this guy was innocent. Okay? And I've been fighting for his innocence and to prove his innocence since 1998. And the Supreme Court needed a hook to hang it on. And the hook they chose was the failure of the lawyer to know that he could have asked the judge for more money to hire an expert. So that's the backstory of Hinton. The fact that it took 16 years for one of the top lawyers in America to get justice for his client is just terribly embarrassing. And then we have Judge Gertner trying to fix things by saying, my God, I read the 2009 NAS report. Things really are a shambles. Lawyers haven't been functioning the way they should. I'm going to issue this standing order, which now says that in every case where a prosecutor intends to introduce trace evidence, he or she has to go on the record about it. And then I expect to hear from the defense request for a Daubert cum hotire hearing, and also a request for funds for experts. So when I knew I was going to speak here today, I contacted Judge Gertner, recently retired, and I said, so after you issued the standing order, how many defense lawyers responded when prosecutors put you on notice that they intended to introduce trace pattern impression evidence? And how many asked for Daubert hearings, and how many asked for funds to hire experts? She said it's really easy. Zero. For the rest of her tenure, there wasn't a single defense application for a hearing or for monies for an expert witness. So again, it's the backstory that tells you, that speaks volumes about how systemic these problems are in criminal justice. And to give you another example, there's a case that's always sort of bothered me for this ineffective assistance issue. And it's a case that started back in June of 1982 in a town of Culpeper, Virginia. And there, a young white housewife was viciously raped and murdered in her garden apartment. And it happened in front of her two toddlers, an infant child. And after the perpetrator fled, she basically stumbled out to the front door and collapsed outside the apartment. And the police came and her husband came, and before she died, she was able to at least communicate that the man who did this was some black man, a stranger, someone I'd never met. And so this became a very, very hot case in Virginia. And in fact, immediately the serology department at the laboratory looked at the evidence. This was pre-DNA. They looked at ABL blood groups and other protein markers. And they looked at a particular protein, which they don't do regularly, because it was a protein where there was a variant that was much more frequent among African Americans than among Caucasians. And sure enough, when they tested it for this protein and this variant, boom, it tested positive. And in fact, in the ensuing investigation, 3 different suspects their blood was typed. It was compared to this blood stain that was recovered from the bloody blanket next to the victim's bed that had this variant, and they were excluded and they were dropped as suspects. A year later, a man named Earl Washington, who was borderline retarded, worked as a tenant farmer, gets picked up when he's drunk one night, and he assaults an elderly woman, takes her gun from her, and shoots his brother in the foot. And when he's interrogated, during that interrogation, he admits that he committed this murder of this young housewife the year before in Culpeper. And after he gives that confession, of course, he's charged with the murder, and then they take his blood. And they compare it to the blood on the blanket, for which they already did an analysis and had excluded those other suspects. So Earl didn't have that variant that was present, that protein that was present on the bloody blanket. And so what the lab did was, they issued an amended report. They didn't do additional testing. They simply issued an amended report, and they said, as to that protein, the results are now inconclusive. So it went from being conclusive, it was a certain variant, to now being inconclusive. And the amended report gets then given to the defense in discovery. Nothing else, just the amended report. Earl has 2 lawyers represent him because it's a capital case. Neither of them had ever tried a capital case. They did a lot of things wrong. But among the things they did wrong was they did not retain the services of any expert at all to look at this report. They didn't seek through discovery the original report that this amended, or any of the underlying data. They didn't understand the science, and they said so. And so he was convicted in a 5-hour trial. The jury took 50 minutes to deliberate on sentence, and he was sentenced to death. He was eventually exonerated through DNA. In 2007, he was completely exonerated, but he had come within 9 days of execution. The DNA not only exonerated him and identified the real perpetrator, who was a serial rapist and murderer who had been working a certain corridor north to south in Virginia. But the interesting thing that I wanted to tell you was that in 1992, when his lawyers stopped the execution, and now he had great lawyers who came in to do this thing pro bono. In 1992, they get to the Fourth Circuit Court of Appeals, and they argue that these lawyers were clearly ineffective. They get an affidavit from the lawyer saying, I didn't understand the science. I didn't know that I should get an expert, that I should ask for the original report. So I never raised the issue of the changed report during the trial. That's a big deal, The Fourth Circuit said, again, looking at the 2 prongs that Bryce talked about in Strickland versus Washington. The first prong is, did the lawyer do a lousy job? Was he unreasonably poor? The second prong is, even if he was unreasonably poor, was there prejudice? Would it have made a difference in the outcome of the case? And what the Fourth Circuit Court of Appeals said in 1992, and then the U.S. Supreme Court denied cert, was that yes, he was unreasonably poor. Terrible lawyering, to miss this whole thing involving the forensic science. But no prejudice, because he had confessed, and therefore overwhelming evidence of guilt. It wouldn't have made a difference, despite the fact that he was borderline mentally retarded and was functioning at a 4th grade level. None of that, and then they had no experts on that. Wouldn't have made a difference. And what's interesting about that is, of course, they said it wouldn't have made a difference in a case where we all now know he was stone cold innocent. And if you go back and you look at all the entire database of DNA post-conviction exonerations, what you'll find is that in 1/3 of the exoneration cases, ineffective assistance of counsel claims were filed at some point during post-conviction proceedings. all right? Only in 2 cases was it actually granted. One case involving 3 defendants in Chicago, and then 1 other case. That's it. What's remarkable about that statistic is not that it's so low, it's that it's so low for people who are actually innocent. And in most of those cases, if you go back and look at the decisions, you'll see that the lawyering was abominable, that the court in almost every instance said they satisfied prong 1 because it was so obviously abominable, but nevertheless, it doesn't make a difference because there's overwhelming evidence of guilt. And of course, these are the findings of judges all over the country, different circuits, different state Supreme Courts, for people who are completely, actually innocent. So it does raise a very serious question about, does this test work? Is the Strickland test the right test? Do we need to change it? Do we need to change the way that appellate courts review ineffective assistance claims rather than simply saying that the error, no matter how egregious it is simply harmless? That's a third of the cases. In 50% of the DNA exoneration cases, we made a determination that there was problematic forensic science in the underlying trial. Now, when we say that, we're not saying that the either unvalidated or misapplication of forensic science caused the wrongful conviction, because you don't know what caused the wrongful conviction, because unless you get into the minds of the jurors. But certainly you can point out what things went awry, whether it was a defective defense attorney, whether there was a misapplication of forensic science, whether there was a prosecutor engaging in misconduct. You can look at them all and say they're contributing factors. And so in 50% of our post-conviction DNA exoneration cases, the misapplication of forensic science, one way or another, was certainly there at the original trial. And what's incredible is that despite that, okay, in total, okay, since 1989, right, although I said there were 4 different people who benefited from IAC claims, only 1 raised a forensic issue and prevailed at an IAC claim. 1, despite the fact that 50% of these DNA exoneration cases involve problems with the underlying forensic science. That's a very serious problem. I know that Jerry mentioned the Hare review that we've been a part of. The FBI has acknowledged in the Hare review that their examiners offered scientific testimony, okay, that was scientifically invalid at the time they offered it. Okay, so I think Jerry's somewhat mistaken when he says, no, the science evolved. It's not a question of evolved science. It's a question of, and by the way, when people say, well, the underlying science is good, it's just the interpretation that's problematic, I think there's some confusion because there's 2 components, okay, to this, and they're both scientific. The underlying bench science, and then we rely on certain scientific principles. They may involve principles of statistics and probabilities, but they're still scientific and mathematic principles for an expert witness to explain to a jury or interpret the evidence and give you a reliable sense about what the probative value of that evidence is. So questions of interpretation involve scientific principles just as much as the underlying bench science does. And so you have an acknowledgement by the FBI that in more than 95% of those cases, of the first 260 trials they looked at or whatever, that their own people offered scientifically invalid testimony. And if you look at those cases, what's remarkable is that I would say in maybe a dozen, the defense called an expert. Okay, and these are situations where they now acknowledge that testimony was invalid. But only in a dozen cases did people even call an expert. In 3 or 4 cases did an appellate court say that the testimony was erroneous. That's it. Okay, and in only 1 of those 270 cases did somebody file an ineffective assistance claim, even though it's now acknowledged by the FBI that the testimony of the agents was erroneous, was invalid. What does that tell you about lawyers and judges and their ability to handle these issues involving the intersection of science and law? I think all these pieces of data that I've shared with you, point to the same conclusion, that the system is not necessarily the best place to solve this problem. And I'll just leave you with one thought, which is, in clinical medicine in our society, in laboratory science in our society, we do not have the general public, the consumers, are not asked to decide whether or not a particular diagnostic tool or whether a particular assay used by a clinical laboratory is valid, is reliable when we utilize it for something. We don't do that with consumers. But in criminal justice, we're actually asking the consumers to do that. You might say that analogy or that comparison is misplaced because actually it's medical doctors who prescribe different assays or different diagnostic tools for us as patients. But in clinical medicine and in clinical laboratories, we don't even ask the doctors with MD degrees to vet the reliability and validity of the different tools they utilize in medicine. Instead, they're evaluated by the FDA, they're regulated by CLIA, the CMS also comes up with additional standards, and the doctors and the public only rely on those devices and those drugs that have passed through all those stages of review. So it's completely absurd, and inappropriate to expect that the legal community, lawyers, defense lawyers, prosecutors, judges, juries are going to get that right when it comes to forensic science. There is absolutely no reason to have that kind of dichotomy and that disparity between those two societal applications of science. It makes no sense at all. And that's why what we've been pushing for long before 2009 is the kind of upstream improvement where the scientific community will take charge of forensic science, where the laboratories will know in advance, what assays, what tools, what devices are valid, are reliable. The burden is not on a defense attorney to show that something is invalid, The burden is always on the proponent in science to show that they have demonstrated the hypothesis. And certainly lawyers, by definition, given what we do and what our knowledge base is, are completely inappropriate to make that kind of representation. So that's why we talk about folks who are involved in the scientific community, getting their ducks in order in advance and having that kind of scientific review. That becomes even more important when you realize that in our society of criminal justice, in the federal courts, 95% of cases are resolved by a plea bargain. In state cases, it's 98%. So people are going to be making important decisions based on a lab report. It's never going to be litigated. There aren't going to be Daubert hearings. There aren't going to be, attacks on the weight of the evidence. It's not going to happen. So you want to get it right from the beginning. And that's what this whole, movement is about. And hopefully, people won't have to think about ineffective assistance because it's an abysmal failure. And they'll think about other ways to get this right. So we as a society and the public and everybody else can rely on that data, can rely on those results for these important decisions involving life and liberty. Thank you.